is the impact of Matrimonial Causes Act and the Child Rights Act on disinheritance? A legally married spouse has standing under the Matrimonial Causes Act to claim maintenance from a deceased spouse estates. And again, under the Child Rights Act, the welfare of a child is paramount, especially for minors. So yes, a will can exclude a spouse or a child, but that decision may not withstand legal scrutiny if the court finds that there was foul play, that there was bad faith, or some other mischief behind the testamentary disposition. Next, we will dig literally into the minds of the dead to find out why testators sometimes disinherit spouses or children. True, it is said the dead don't speak, but sometimes the dead speak through court decisions, through wills, and through evidential or documentary evidence that is available for us to look at. The ways in which they speak show us sometimes that disinheritance is often rooted in personal relationships, perceived or actual wrongs, disloyalty, betrayal, or shifting loyalties, or sometimes the overarching commitment of a patriarch or matriarch to protect the estate from wasteful or irresponsible children, or even wayward spouses. But not every emotional reason holds water in law. Let's look at some of them. And they include adultery or marital infidelity. Quite often, testators disinherit spouses for perceived or real infidelity or adultery. Whilst morally weighty, adultery is not an automatic ground for lawful disinheritance unless it was judicially determined and the marriage was dissolved. You may forgive me if you don't agree with me, but that's what the law says.